The end of finality, a new era for naturalized citizens. For more than 26 million people, naturalized U.S. citizenship was always viewed as the final step of the immigration journey, a lifetime guarantee that their status could never be questioned again. It symbolized stability, belonging, and the absolute end of years of paperwork, interviews, and legal uncertainty. However, as we move toward 2026, a new and aggressive immigration crackdown is taking shape, forcing many to ask a frightening question. Could my American citizenship actually be taken away? Quietly, behind government office doors, internal policies are shifting, and old cases that have remained untouched for decades are being reopened and reviewed. Unlike past enforcement efforts that focused primarily on borders, new arrivals, or visa overstays, this new approach looks inward at those who have already gone through the legal process, took the oath, and built their lives as Americans. This represents a fundamental shift in the government's philosophy regarding citizenship. For years, the process of denaturalization, the legal revocation of citizenship, was considered an extraordinary and extremely rare tool, reserved only for the most serious threats to national security or cases of intentional high-level fraud. But reports now suggest that the assumption of once American, always American is being tested in ways most people never imagined. Over the next 15 segments, we will break down exactly what is changing, who is truly at risk, and how to navigate this unsettling new enforcement landscape with facts and preparation instead of fear. The statistical shift from rare to routine. To grasp the magnitude of the 2026 crackdown, we must look at the staggering shift in historical data. For decades, denaturalization was an extraordinary legal tool, an absolute last resort used only in extreme cases of national security threats or war crimes. Between 2017 and 2025, the U.S. averaged only about 15 denaturalization cases per year nationwide. In a country of over 300 million people, this made the revocation of citizenship almost unheard of for the average law-abiding person. However, the new 2026 enforcement posture has introduced a radical change. Internal reports suggest that USCIS field offices are now being encouraged to identify between 100 and 200 potential cases every single month. This could drive the annual number of filings to between 1,200 and 2,400 cases, a nearly 100-fold increase compared to historical averages. When enforcement moves from exceptional to systematic, the nature of the system itself changes. Instead of focusing only on the most dangerous individuals, there is now an institutional pressure to find problems within files that were approved decades ago. This numerical target system is what has legal experts and immigrant communities on high alert, as it raises the possibility that minor errors may no longer be overlooked in favor of meeting enforcement quotas. Understanding the legal threshold, Section 340. Despite the aggressive headlines, the fundamental law governing citizenship revocation remains anchored in Section 340 of the Immigration and Nationality Act. Under this statute, the government cannot simply cancel your citizenship because of a policy change or a new administration's preference. To successfully strip a person of their American status, federal prosecutors must prove that the citizenship was illegally procured or obtained through willful misrepresentation of a material fact. This legal definition is a vital protection for naturalized citizens. A willful act requires proof that the deception was intentional, not a simple memory gap or a translation error. A material fact means the information was so significant that, had the truth been known, the government would have legally denied the naturalization application. For decades, this high bar served as a safeguard, ensuring that only those who fundamentally cheated the system were targeted. However, as we enter 2026, there is concern that the definition of materiality is being stretched. What was once considered a minor clerical oversight, like a forgotten short trip or an incorrect address history, is increasingly being scrutinized as a potential ground for legal action. Understanding this legal threshold is the first step in differentiating between a routine review and a genuine legal threat. The internal review mechanism, reopening the past. The current crackdown is unique because it is not looking at people coming across the border. It is looking backward at those who have been citizens for years. USCIS offices across the country have reportedly been directed to shift their focus from processing new arrivals to conducting deep dives into archived files. This internal review process aims to identify discrepancies between old paper-based applications and modern digital records. Many naturalized citizens applied decades ago, filling out complex forms in a second language, often without legal counsel. At that time, government databases were not interconnected, and many details were verified manually. Today, those same individuals are being measured against a highly integrated digital landscape where fingerprints, travel records, and tax filings from various agencies are cross-referenced in seconds. If an application from 1995 contains an employment date that doesn't match a newly digitized Social Security record, it can flag the file for an enhanced review. While the goal is supposedly to correct past fraud, the reality is that many honest citizens now fear that normal human imperfection from 30 years ago could be weaponized against their current life in America. The digital net, technology versus legacy records. A major driver of the 2026 enforcement push is the massive technological upgrade within the Department of Homeland Security. For years, lost files or incomplete paper records provided a natural limit on the government's ability to revisit old cases. However, the widespread digitization of immigration records has removed that barrier. Automated systems can now scan millions of documents simultaneously, looking for red flags, such as conflicting names, dates, or prior visa denials that might have been omitted on a naturalization form. This digital net is particularly sensitive to travel history and biometric data. If a naturalized citizen's old fingerprints match a different name in an international database, or if their exit entry records show a longer absence than they reported on their N-400 application, the system generates an automatic notice. While these tools are designed to catch serious criminals or those using false identities, they often lack the nuance to distinguish between a deliberate lie and a miscalculated travel date. For the 26 million naturalized citizens in the U.S., this means their past is no longer settled history, but a searchable database that can be requeried whenever the political or enforcement climate changes. Identifying high scrutiny categories. While the crackdown is broad, the government is not reviewing every file with the same intensity. Authorities have emphasized that their primary targets remain individuals who allegedly concealed serious misconduct to gain entry. This includes four main categories: individuals with hidden criminal histories, those who committed marriage fraud, people with ties to extremist organizations, and those who used completely false identities. For example, if an individual obtained a green card through a sham marriage and then used that green card as the foundation for citizenship, the entire legal structure of their status is considered fraudulent. Similarly, the use of a false name or date of birth to hide a prior deportation is a top priority for denaturalization prosecutors. Government officials argue that these measures are necessary to clean up the system and ensure that citizenship remains a privilege for those who followed the law in good faith. However, the fear in 2026 is that as offices struggle to meet their monthly referral targets, they may begin moving down the ladder of severity, targeting individuals for increasingly technical or minor misrepresentations that occurred decades in the past. The interconnected web, IRS, FinCEN, and USCIS. One of the most significant developments in 2026 is the implementation of real-time data sharing between the IRS, the Financial Crimes Enforcement Network, FinCEN, and USCIS. This isn't just a change in tax law, it is a powerful new enforcement tool for immigration. Under the new rules, every piece of financial information you report on your taxes, especially foreign accounts and pensions, is automatically cross-checked against your immigration records. For naturalized citizens and green card holders, this means that good moral character is now being measured through tax compliance. If you answer no to a question about foreign accounts on your tax return, but a data sharing agreement with a foreign bank reveals an account in your home country, it triggers an immediate inconsistency flag. USCIS can then use this misrepresentation as a reason to look deeper into your entire history. In some cases, failing to report a small savings account overseas can be interpreted as a lack of the good moral character required for citizenship. Or it could be used as evidence that you lied on previous immigration forms. This interconnected web makes it nearly impossible for financial discrepancies to remain hidden from immigration authorities. The impact on Indian American communities. The 2026 crackdown is being felt with particular intensity in the Indian American community. After Mexico, India is the second largest source of naturalized U.S. citizens, with nearly 50,000 Indian-born immigrants becoming Americans in the last year alone. Many of these individuals spent decades on H-1B work visas, building careers in technology, medicine, and engineering, while navigating an incredibly slow green card backlog. For them, naturalization was the final victory after a marathon of uncertainty. Now, many of these families are facing a new kind of anxiety because they maintain deep ties to their home country, often keeping bank accounts to support aging parents or holding interests in family property. They are highly susceptible to the new, lower financial reporting thresholds. A technical error on an old form or a misreported foreign retirement fund can suddenly put a decades-long immigration journey back under the microscope. Attorneys report a surge in calls from Indian American citizens worried that technical inconsistencies from their many years in temporary visa status could now be re-examined as material misrepresentations. For a community that prides itself on following the rules, the idea that their hard-earned stability could be fragile is deeply unsettling. The chilling effect. Fear of travel and interaction. Beyond the courtroom, the 2026 policy has created a profound, chilling effect across all immigrant communities. Many naturalized citizens are becoming fearful of simple, routine actions. Some are hesitating to travel internationally, worried that an encounter with a Customs and Border Protection officer could lead to a secondary inspection or a questioning of their original naturalization file. Others are avoiding interactions with government agencies entirely, choosing not to renew documents or apply for benefits out of fear that it will invite unwanted attention to their records. This environment of fear can erode the very sense of belonging that citizenship is supposed to provide. When people start to view their own legal status as conditional or on probation, the relationship between the citizen and the state changes. Critics of the crackdown argue that even if few people actually lose their citizenship, the psychological damage is already being done. A two-tier system is emerging, one for natural-born citizens whose status is never questioned, and another for naturalized citizens who feel they must constantly be ready to prove their worthiness. Staying informed and organized is the only way to combat this chilling effect and reclaim the security that citizenship was intended to guarantee. Constitutional guardrails, the 14th Amendment, shield. In times of high enforcement, it is critical to remember that the U.S. Constitution remains the ultimate anchor of your status. The 14th Amendment explicitly grants citizenship to all persons born or naturalized in the United States. This means that once you have legally naturalized, you have the same fundamental rights as any other American. You cannot be deported, your right to vote cannot be taken away by an executive order, and your status does not expire. The Supreme Court has repeatedly affirmed that citizenship is a constitutional status, not an administrative one. This distinguishes you from green card holders, whose status is governed by agency rules and can be revoked more easily in immigration court. While the 2026 crackdown is aggressive, it cannot override the Constitution. The government must still follow due process, meaning they have the burden of proving fraud through a formal legal process. For the vast majority of naturalized Americans who were honest during their application process, the 14th Amendment provides a nearly unbreakable shield against arbitrary enforcement. The judicial process, your day in court. If the government does decide to pursue denaturalization, it is not a quick administrative decision made behind closed doors. This is one of the most important things to understand. The government must file a civil lawsuit in a federal district court. You are the defendant in a legal proceeding, and you have significant rights. You have the right to hire a lawyer, the right to discovery, where the government must show you the evidence they have, and the right to a trial before a federal judge. The burden of proof rests entirely on the government, and the standard is clear, unequivocal, and convincing evidence. This is a very high bar, much higher than the standard used in regular immigration court. The government must prove not just that there was a mistake, but that you intentionally lied about a fact that would have disqualified you from citizenship. Because these cases are expensive and time-consuming, they remain relatively rare despite the increased referral targets. Understanding that you have a day in court is a vital defense against the fear of sudden bulk revocations. Practical protection. Organizing your history. In an environment of increased scrutiny, preparation is your best defense. Immigration experts recommend that all naturalized citizens conduct a personal audit of their records. This involves keeping a secure folder containing your original naturalization certificate, copies of every form you ever filed with USCIS, and all supporting documents such as old passports and tax returns. If you do not have copies of your old applications, you can file a Freedom of Information Act (FOIA) request to obtain your complete A file from the government. Being organized eliminates the stress of searching for records if you are ever asked a question during a passport renewal or a family sponsorship petition. If you find an inconsistency in your past records, consult a licensed immigration attorney, not a consultant or notario, to understand the best way to handle it. For the millions who followed the rules, these records will simply confirm your legal status. Remember, many delays in the system happen not because someone did something wrong, but because they couldn't quickly prove they did things right. Organization transforms a moment of panic into a routine verification. Protecting the family. The case for naturalization. A common question in 2026 is whether it is safe to apply for citizenship given the current crackdown. While the interviews are more detailed and the background checks are more layered, the answer from most legal experts is a resounding yes. Permanent residents are actually more vulnerable than citizens. A green card holder can be placed in removal proceedings for certain crimes or extended absences, and their status must be renewed every 10 years. Citizenship provides a finality and a level of constitutional protection that a green card simply cannot offer. Once you take the oath, you are no longer subject to immigration enforcement rules. Therefore, if a family member is eligible, 2026 is the time to encourage them to naturalize. Yes, they should be meticulously honest and well prepared for the interview, but reaching the finish line of citizenship is the best long-term security move for any immigrant family. Stability at the top of the ladder, citizenship, is the best way to protect everyone on the rungs below. Guarding against scams and misinformation. Whenever there is fear and a crackdown in the news, scammers and predatory services flourish. You may see advertisements from organizations promising to protect your citizenship for a fee or claiming you need to file special safeguard paperwork with the government. It is vital to know that these services are almost always fraudulent. Your citizenship is protected by the Constitution, and there is no insurance or special registration that can make it more secure than it already is. Be extremely cautious of anyone asking for large cash payments to fix your record or guaranteeing a specific outcome with the government. Only trust information from official sources like USCIS, the Department of Justice, or reputable licensed immigration attorneys. If you receive a suspicious letter or call claiming your citizenship is under review, do not provide personal information over the phone. Contact a qualified lawyer immediately to verify the communication. Protecting your personal data and your wallet is just as important as protecting your status during this high enforcement period. Conclusion: stability in a changing climate. As we wrap up this deep dive into the 2026 immigration landscape, the core message is one of cautious confidence. Yes, the enforcement climate has become more visible, the technology has become more precise, and the internal targets for review have increased. This shift is real, and it is creating genuine stress for millions of naturalized Americans. But visibility is not law, and rhetoric is not a constitutional amendment. Your citizenship remains one of the strongest legal statuses in the world, anchored in decades of Supreme Court precedent and the 14th Amendment. For those who obtain their status honestly, there is no secret mechanism that can suddenly undo your American life. By staying informed, keeping your records organized, and understanding your rights, you can replace anxiety with the clarity needed to protect your future. You earned your place in the American story through hard work, patience, and the oath of allegiance. Do not let a noisy political environment take away the peace of mind you have rightfully earned. Stay organized, stay prepared, and live your life as the full American citizen you are.